we had a sidebar conference. I'm asking the court to consider, since he's been in about 4 months now, a bond reduction. He needs to get out and get services.
I would only indicate, and we did have that the court, if council were able to structure something that would permit his release, but that release would have to include some type of treatment as well as the defendant following a medication protocol. Without that, I'm gonna not change his bond. What do you wish me to do in the case?
Your Honor, I'd like a 2-week adjournment.
Probable cause conference will be adjourned January. Who are you?
I just have his mother and I are Florida residents.
Are what?
Florida residents.
I'm sorry to hear that. No, go ahead.
And I've exhausted all means of trying to get this simple letter with 3 pages of paper with there's a storage unit a mile and a half down the road with all his belongings, stuff that has code and a key in it. And we're going back to Florida. This could just be easily put in kind of his personal belonging, so that when he gets released, he can have this easy when he gets out.
Why don't you talk to his attorney about that?
We don't have his client's consent. No consent from the client.
Yeah, all you want.
I've tried the front desk, I've tried the door, 8384, whatever it is, and it's just all.
R4. Go ahead. To who? Me?
To the officer right there.
Dear God.
I won't.
Do you care if that letter goes into your personal belongings, sir?
Not at all.
Not at all? Great. Will you give the public defender authority to take the letter and make sure that it gets to the jail and in your public property?
Yeah, and
Will you do that? Great. Fantastic. Problem solved.
can I address everything?
I told him what you told me in the lockup.
I'd like to just, I've been in here, I've looked at other cases and it's 9 days people spend for this sort of charge. I had a pretty bad day, I'll admit that. Some of my behavior was not acceptable. I'll put that in front of everybody. It wasn't, I was walking on.
Well, I don't want you saying anything about the case.
But well, I just want to make it clear. I've
Sir,
been.
Did you hear what I said?
I've been doing. I heard what you said, but I think it's
But you don't
unfair. I think it's. I think I could be released. I've been in here for over 100
Sir,
days.
I don't have a problem. Listen to what I said. I don't have a problem releasing you as long as there is a structure regarding your treatment, as well as a medication protocol that you agree to follow.
The medication protocol is what I'm contesting. I benefit from therapy. I've worked with a therapist. The whole issue is I lost healthcare back in May, and I was trying to get it back. I wasn't able to, and it's just a matter of getting insured and talking to a therapist. I don't think that there's a risk of me being out in public, and I think me being detained for over 100 days without only 1 hour out. I'm spending 23 hours of my day inside of a cell, and that's not conducive to me getting better. It's what's going to be this situation resolved.
So which part of what I said do you not understand?
I understood, but I disagree.
Okay. So noted. Thank you. Bond continue.
Where was the new date?
I forgot now. The 9th.
Mr. Drobashevsky.
This is about bail reduction too, and I have information here.
Robert Edward Drobashevsky. Good morning, Your Honor.
Good morning, sir.
Your Honor, I submitted to the court 2 findings and orders on competency. We would stipulate to the forensic examiner's report and ask the court to opine him restored to competency.
People have nothing further.
But I already found that he was competent last time we were here.
Okay. Thank you, Your Honor. I wasn't
set
sure
for
that-
probable cause today.
Understood. We're asking for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people, I realize this has been going on some time, but would people have their witnesses available on the 7th? Yes.
Argument for bail
I know. I'm
modification
going,
today.
I'm going to. Chill out. I'm going to. Your Honor, when the court has a moment, may I briefly address bond?
Preliminary examination will be set January 7th, 2025, 9 a.m. before Judge Barr. As to bond.
Your Honor, bond in these cases is a combined $525,000 cash. Mr. Drobushevsky has been in custody since January 14th of this year. I believe the complaining witness, Ms. Lerma, is in court today and would join us in asking the court to consider a personal bond in both of these cases. In the event Mr. Drobushevsky were released from custody, he could return to the residence he was previously residing at. And I believe Ms. Lerma, the complaining witness, would live at a separate residence. I know Mr. Drobushevsky was getting support from the VA. I think he would be able to get that support for his mental health from the VA or released. I know his mental health has improved, as evidenced by forensic court. So we just ask the court to consider reducing bond in both the cases.
Respond.
Your Honor, aside from a lengthy history, including assault with injury from dating back all the way to 1994, multiple RNOs, multiple obstructing, multiple interfering with crime reports, as well as a prior DV. We have one case that involves 9 counts, aggravated stalking, weapons, larceny, domestic violence, tag along, witness intimidation. I think based off of that alone, not facts, the $525,000 cash is appropriate. But looking at the facts of the first case, the defendant held a weapon, once again, a gun, and the other time a knife to the victim's head, threatened to kill her if she did not quit her job and sell her home. The defendant texted the victim times, alarming threats, including, "I'm coming for your head. If it's my last breath, if it's my last breath on this earth, I'll take you, and I will have your head in my hand. I'm taking your head and shooting you in the pussy for payback." There are a few of the, and these are just a few of the many threats that he made. That's just from the first case. There was a separate group of allegations amounting to witness intimidation. I don't think reduction at this point is appropriate.
Your Honor, Mr. Drobushevsky has prepared 2 letters for the court. If I may review those and submit a written motion, would the court reconsider it?
Motion for bond reduction is denied. You can submit, of course, and the court will take it up when it's submitted to it.
Thank you, Your Honor.
Thank you.
No.
Thank you, Your Honor.
You're welcome, sir.
Yes, I'm good.
Destine Cheatham.
Good morning, Your Honor. Mary Tana, Assistant Prosecuting Attorney on behalf.
Morning, I'm Rob Jacob on behalf of Destiny Cheatham. Destiny, would you state your name for the record?
Destiny Cheatham.
Judge, since you're adjourning the other matter to the 9th, can we also adjourn ours?
I will, however, she's in violation of her bond.
Judge, here's the thing. I'm not sure the mom was aware of that and my client wasn't aware of that. Mom brought both girls here. I talked to the mom. She will take one of the girls home and call somebody else to pick up the other girl if necessary. But I'm not sure my client was aware that there was no contact order.
Well, first of all, thanks to Mom for bringing them because they were not here last time and had to be picked up by fugitive team. So I do appreciate that. However, Ms. Cheatham was made aware. I was, as I stated, at the arraignment where she was specifically asked if there would be a problem with her not having contact with her sister by Magistrate Fink, if there was a reason that she needed to have contact with her sister. And the answer was no.
Judge, when I did see them out in the hallway, they were far apart. They were not discussing. It's just that
Yeah, but
the-
they came, so that's part of the problem is, and I understand maybe what mom's doing, but part of the problem is she knows she's not supposed to have contact.
well, she will have no further contact with her sister. And mom can get somebody to come and pick her up if the court would just give her one last chance.
Governor, if I may, the problem here isn't just this one situation. The problem is there have been very clear instructions by the magistrate and potential district court on what to do, what's allowed and what is not. And the backup problem, the bigger problem is they also failed to appear after magistrate made it very clear that that was not an option. Now, I'm quite frankly surprised they're not in custody, given the procedural history of this case, but here we are. I'm glad they're here. Hopefully we can get these cases moving. This involves distributing material that involves sexual acts committed by a minor. This is no joke. The court is somewhat because you had one of the other co-defendants.
Yeah.
And we had difficulties there as well. So I'm not sure why it's so difficult to show up and follow no contact provisions, but it seems to be a problem.
Judge, she's here today. She
Did
said
you
at the
post the
agreement,
bond?
pardon me?
Yes.
Okay, that's why she's out. She posted the bond, but then violated the bond. What is that?
Judge, they were in a cell together when they were being arraigned. Again, Judge, I'm just asking if the court would please consider, she understands now. If she did make a mistake, it was unintentional. She's just asking.
Well, hold on a moment. You live in Ann Arbor or Ipsy?
Yes.
Pardon?
Yes.
Which one you live in, Ann Arbor or Ipsy?
Ann Arbor.
The other young lady lives in Ipsy, so why are they together? And the prohibition is on your client, Mr. Killalone.
Judge, I didn't know that at the arraignment. I wasn't at the arraignment, so I can't tell you why she didn't. All I'm at, she made a mistake. I'm asking the court. Pardon me?
My mom brought us together. I didn't.
Okay,
She had to
just,
pick us.
you're not gonna get anywhere. She made a
There.
mistake, Judge. She will not make it. She'll go
It's
home
not a
separately.
mistake. She knows what the bond conditions are. Mr. Allen. Who are you? Okay. What do you want to say?
I got bills trying to get them out. They will come back to work. I was unaware of all the no contact. She lived with.
Mom, I get you were, she wasn't.
Thought when she had got out on the personal bond, that they had said, yeah, but she wasn't aware at this time. She just got confused. No, but they will not be with each other again.
Judge, there's no allegation that they were in a hallway talking about this. It was, and again, I don't mean to minimize what happened, but the mom picked the girls up. Again, it was a mistake on their part. They will have no contact. You can be assured of that. I just can't see putting this young lady in jail. She came to court
She
today.
violated, first of all, you can't see it. She didn't appear. So we had to issue a warrant. My understanding is they had to have a team go out, pick her up. She gets here, she gets her bond conditions, and then violates the bond conditions.
They were separated in the hallway, Judge. I can't explain why mom picked them up, but they were not together in the hallway. They were not conversing. They were not talking
She
sister
should
to
have let
sister.
mom know she had that prohibition. I'm not blaming mom. Mom is doing what mom will do. I'm blaming her.
Judge, again, this is a very serious case.
It is, and that's one of the reasons why that condition is on there.
I understand.
And she violated it. Well, first, like I said, first of all, she doesn't appear. Then she violates it.
If defending this young lady would, and again, would be much easier, her being out of jail. I'm asking the court to give this young lady one last chance, Judge. And whatever's going to happen, please hold over the violation till we do the exam.
Now, I think at this time, I'll reconsider it, but right now she's going back. Mom can get the other daughter home. I will reconsider exactly whether I'll leave her in there at noon today.
Thank you.
Ma'am, I have a docket. I have a docket starting at noon, another block. I will reconsider it in that time. I'm not blaming you. I understand what you're saying. She knew she wasn't supposed to do that. And that's the problem I'm having. Okay? So I'm going to take all of that into consideration, take a close look at it, and then make a determination at noon as to whether or not I'm going to let her back out. Okay, thank you.